Thanks very much, Raina, for that interesting introduction. You see all sorts of things on the internet. I'd start by acknowledging the traditional owners of the land on which we meet, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders, both past and present. And I'd acknowledge, among many distinguished guests, Alastair Nicholson, former Chief Justice of the Family Court of Australia and former Justice of the Supreme Court of Victoria, Mark Snedden, Crown Counsel for Victoria, who's here, Raina Tang, who's very kindly introduced me, Michael Brett Young, the CEO of the Law Institute, many other distinguished guests, and I include in that a very important person in my life, my clerk, John Kelly, who's here just to check on my welfare and to make sure that if I ever return to Foley's List, I'll still be able to do the job. And I'd also acknowledge my two family members that are in the room, but I won't embarrass them by identifying them. It is a pleasure to be back here talking to a Law Institute of Victoria lunch. There are very, very many familiar faces to me in the room, people with whom I've worked over the past 30 years, and it's nice to be back in home territory. I want to thank the Law Institute of Victoria for inviting me here to speak at its first leadership lunch of 2013, to outline my priorities as Attorney-General and to convey my views on the opportunities and challenges that are facing the Australian legal profession today. I have assumed this role at an interesting and, as some have pointed out, challenging time in the parliamentary cycle. But to me, such timing does not matter. I do consider it the highest privilege to be serving as the Attorney-General and First Law Officer of the Commonwealth. It's a role that carries with it a responsibility to advance fairness, justice and prosperity across Australia, no matter where you live and no matter what your background, wealth or status is. And while I'm going to talk to you today about the policy priorities that I've set, the fact of our federation means that I am not the only First Law Officer around here, and that I must at times negotiate my agenda with state Attorneys-General. Sometimes those negotiations go very well. Just had a very useful chat with Mark Snedden on behalf of his Attorney-General for Victoria. Sometimes not so well. I expect that legitimate differences will arise from time to time, but I must say I had not expected to be in an argument with the Queensland Attorney-General about laws to modernise royal succession. The laws were agreed between Prime Minister Julia Gillard and Prime Minister David Cameron quite some time back, at around the time of the Commonwealth Heads of Government meeting in Perth, and do need to be passed by all of the parliaments of the 16 Commonwealth countries that still have the Queen as their head of state. The laws will remove archaic and blatantly sectarian and sexist succession rules such as the preference for male heirs, the disqualification of an heir if they marry a Catholic, and the requirement for certain people in the line of succession to get royal permission to marry. You might think that this basic modernisation of succession arrangements would be uncontroversial, but it seems that Mr Blay, that's the Queensland Attorney-General, has concerns and is looking to draft his own laws to ensure that should Australia become a republic, Queenslanders will somehow remain subjects of the British Crown. Perhaps he is channeling the spirit of Joh Bjelke-Petersen. In any event, I've sought to assure Mr Blay that should Australia become a republic, his state will not have to change its name to President's Land. Despite distractions of this kind, and you might be thinking I made all that up, but it's current, this week. It's going to be raised at COAG tomorrow. Despite distractions of this kind, I have set an ambitious but realistic agenda as Attorney-General, one that builds on the work of my immediate predecessors, Robert McClellan and Nicola Roxon, while driving changes to more fully realise true access to justice in this country. It is an ideal, I acknowledge, but every Australian should be able to exercise their legal rights or avenues to resolve their disputes fairly, quickly and with confidence. Moving closer to this goal will require the commitment and cooperation of the profession as well as government. I have introduced, and Raynar mentioned this, and will be steering through Parliament long overdue legal protections for the gay, lesbian, bisexual, transgender and intersex community. The Australian Labor Party has made this country a fundamentally fairer place by driving anti-discrimination reform over the past 4 decades, and that's why I demand explanations from those who would seek to wind back hard-won legal protections against racial vilification under the guise of free speech. And I'm pleased to see that my goal to foster and celebrate greater diversity across the profession, from article clerks to federal judges, accords with the stated aims of the Institute's 2013 executive. Since becoming Attorney-General, I have been looking very hard at the issue of access to justice in our country. As I've made clear in some of my recent remarks on this topic, I believe that access to justice means more than simply the ability of individuals to enforce their legal rights in our courts. Access to justice is a concept that also relates to how institutions of state, of which the formal justice system is only one part, operate to ensure that all Australians live under the protection that our laws intend to provide. So while people must always have the opportunity to fight for their rights in court, justice in a society under the rule of law should not be something individuals must constantly be fighting for. Rather, justice should be integral to our way of life. And I think that an analogy can be drawn between the legal and medical spheres and the idea that prevention is better than cure. Because in some ways, litigation can be compared to surgery. While both may be sometimes necessary and indeed essential, both are very unpleasant for the subject and both are very expensive, whether it is the individuals concerned or the wider community that ultimately pays the bills. Cleaning up the blood and gore afterwards is also something of a chore, particularly in the case of litigation. So just as the best outcome for the health sector is to build a healthy society in which the need for hospital admissions is minimised, I feel we should be working to build a more just society in which the need to go to court to achieve justice is also minimised. For example, the Royal Commission into Institutional Responses to Child Sexual Abuse will hear from hundreds, if not thousands, of witnesses who have suffered terrible injustices as victims of child sexual abuse. And there is justice for the victims of these shocking crimes in being at last able to be heard, to be believed, to be acknowledged. But the Royal Commission will go far beyond just listening, just providing that opportunity for people to be heard. It will investigate where systems have failed to protect children and make recommendations on how to improve laws, policies and practices to prevent and better respond to child sexual abuse in institutions in the future. In this way, the Royal Commission will help to build a more just Australia by ensuring that the most vulnerable members of our community are far less vulnerable to the appalling injustice of abuse. Now, although I've given you an expansive definition of access to justice, there's no doubt that the formal justice system has a critical role to play in establishing a society under the rule of law. And providing access to the formal avenues of justice requires that we continue to build a highly functional and responsive framework for the provision of legal assistance services. And this is in part why I recently announced the evaluation of the Civil Dispute Resolution Act. I call on legal professionals, alternative dispute resolution practitioners and members of the public to help evaluate its efficacy. There do remain misconceptions about what is required under this Act. It does not require parties to take any steps before starting proceedings. It is up to the parties to decide what steps they try to take to resolve a dispute before filing litigation, if any. It depends on the nature of their matter, and the requirement is to simply outline these in a genuine steps statement. Anecdotally, these actions and statements are proving useful to the judiciary when matters do ultimately end up in court. Some of you might have seen a quite spectacular reference to the genuine step statement in the judgment given by Justice Rearies in the Federal Court, condemning the abusive process involved in the pursuit of the former Speaker of the House of Representatives, and there's quite a number of passages in the judgment about the genuine step statement there. But leaving that example to one side, the government needs to know whether this Act, the Civil Dispute Resolution Act, is meeting its goal of encouraging the early resolution of disputes without the inevitable cost and stress of going to court. Speaking of cost as a component of access, this might be a good moment to explain some recent court fee changes. Any fee increase, I can say in isolation, can appear to limit access. But all of us would know that court fees often comprise only a very small proportion of total legal costs incurred by litigants. Court fees have now been structured to better reflect capacity of different litigants to pay. Fee changes are balanced by a number of measures, including reinstating full fee exemptions for disadvantaged litigants and treating small businesses as individuals rather than as corporations. And an additional $38 million from these additional fees is being directed back into our courts to ensure that they are able to provide the services that communities need, including regional circuit work. This additional funding, as a result of changes to court fee structures, will place the courts on a firmer financial footing. And I've been quite open that I will be closely monitoring the operation of the fee changes and acting if any negative consequences are identified. That's why I have warmly welcomed the Senate committee inquiry into these fee changes, even though I was disappointed the committee missed the opportunity to examine court costs as a proportion of total legal expenses. I was invited by Rayner to deal with legal aid issues, legal aid in Victoria, and I would start by making the point that the Australian government's contribution to legal services nationwide over the 4 years to 2015-16 will be $1.35 billion. Of that, $844 million over that 4-year period is for legal aid nationally, under the National Partnership Agreement that's presently used to provide the Commonwealth funding to legal aid commissions, state and territory. Victoria Legal Aid has received a significant increase in funding from the 2010-11 budget of $36.12 million over 4 years, and in this current year, 2012-13, Victoria Legal Aid will receive $44.3 million of the national budget total of $212 million for the 8 legal aid commissions. It's true, as Rayner says, that we have not yet returned to the 50% of Commonwealth funding that was the case until 1997, when there was a, I think savage would be the right word, it's an overused word, but a savage cut to legal aid funding by the Howard government at the time of the introduction of this notion of a Commonwealth legal matter, which is still used by the Commonwealth. But over the course of the 5 years of Labor government, since we were elected in 2007, I can say that there have been some very substantial rises, most notably the rise that was put in the 2010-11 budget. I'm fearful that I have come somewhat late in the budget cycle, having been appointed on the 4th of February this year. Any of you that have got any familiarity with the budget process in Canberra would know that budget deliberations start well back from the 4th of February, more likely around October, about the same time as we put the mid-year economic and financial outlook, what used to be called the mini-budget, to bed. Immediately work starts on the next budget to be published in May. Becoming Attorney-General on the 4th of February has presented me with some unique difficulties in having my say in what should happen on legal assistance, and I, like all of you probably, are waiting to see what is in the budget to be announced by the Treasurer in the second week of May. I'd say this about the position with Victoria. Of course it is the case that we work towards cooperation, and cooperation is better with some states than with others. Victoria, I was pleased to see this week, has settled a quite long-running dispute over wages and conditions at the Victoria Legal Aid Commission. But it's also the case that the Victorian government has made changes to legislation and policing arrangements which appear to have increased demand from vulnerable people for legal assistance in relation to criminal law matters. And many of you would be aware that Victoria Legal Aid's amended guidelines for criminal law matters has led to the courts staying some criminal proceedings quite recently. And I'd say just this, that if a Conservative government, such as Victoria presently has, wants to run law and order policies that look like law and order policies from the 1950s, the least that I would expect that government to do is to pay for any increased legal demand that flows to legal services from those kinds of policies. And this is a problem that we are dealing with in other parts of the Commonwealth as well. Queensland, Northern Territory and to a lesser extent New South Wales have also introduced what they describe as law and order policies that do produce very direct impacts on demand for legal assistance, which at the same time those Conservative governments are not properly funding. Structurally, there is a review due of the National Partnership on Legal Assistance Services. That's it's a document that plays a central role in the national government strategy for improving access to justice for disadvantaged Australians. It's a national partnership agreement that covers a great deal more than legal aid. It was entered into, and I'll quote from it, to provide a national system of legal assistance that is integrated, efficient and cost-effective and focused on providing services to disadvantaged Australians in accordance with access to justice principles. It's an agreement that has provided a framework for innovation and reform, and some of the reforms sought under the agreement have included initiatives to drive earlier resolution of legal problems, more effectively targeted services, increased collaboration and cooperation between legal assistance and other providers of services relevant to justice in a broader sense, and a strategic national response to critical challenges facing the sector. And some of those objectives have been met better in some states than in others. Most notably, there's been a lot of very, very effective work done by legal aid agencies and community legal centres in forming partnerships with other NGOs, charitable sector organisations, social service organisations that intersect with them, and which was the intention of the National Partnership Agreement. The review that is currently being conducted of this National Partnership Agreement aims to give us a national picture of the legal assistance system as a whole, and it should tell us what we're doing well, where we need to improve. It should tell us if we're targeting services appropriately, and it should give us data on how well legal assistance service providers collaborate with each other and with other support services that work closely with the legal assistance sector. I'm looking forward to seeing the findings of this important review when it is completed in a few months' time. I wanted to make some remarks about pro bono work because pro bono work by the legal profession does play an important role in improving access to justice in our community by providing legal assistance to many people who would otherwise not receive it. I know that everyone here today appreciates the social good that we can all achieve as legal professionals through participating in pro bono work, and I was very pleased to hear the findings from the recent National Pro Bono Resource Centre survey, which showed an increase in the amount of pro bono work undertaken by the Australian legal profession. I want to acknowledge the significant pro bono work that the Australian legal profession contributes to our community. Just to give some stats, since the introduction of the National Pro Bono aspirational target in 2007, the number of lawyers undertaking pro bono work has trebled to over 8,000 lawyers nationally, and in 2011-12 these lawyers undertook over 260,000 hours of pro bono work, which is a significant achievement, and those who participate in pro bono work are to be congratulated for it. The Australian legal profession can hold its head high when it comes to willingness to undertake pro bono work. but there is always room to do more to ensure that disadvantaged Australians are not passed over when it comes to accessing justice. The Australian Government's committed to working together with the legal profession to enable and encourage pro bono legal work, both in Australia and internationally in our region, and to this end the Australian Government funds the National Pro Bono Resource Centre, which provides national leadership to the pro bono sector and develops and shares best practice resources. The Australian Government has also sponsored the National Access to Justice and Pro Bono Conference, which promotes and shares approaches to access to justice and pro bono best practice from around the world. A new Commonwealth Legal Financial Assistance Scheme was established in July 2012 to provide funding for certain disbursement costs in Commonwealth matters such as expert reports, counsel's opinions and court transcript costs. It's a scheme which supports lawyers who are wishing to undertake pro bono work by reducing the barriers to access to justice that are created by disbursement costs. The Australian Government's also committed to promoting the rule of law and building capacity through pro bono work in the Asia-Pacific region, and I'd acknowledge the significant contribution of the legal profession in delivering quality pro bono legal services overseas. Pro bono work cannot and should not be expected to replace the provision of government legal services for those in need. However, it is an essential mix of the services that the Australian Government and the legal profession provide to enhance access to justice in the Australian community.